folks. I'd like to bring the regular meeting of the Law Enforcement, Public Safety, Health, and Welfare Committee meeting to order. And if you would like to have a moment of silence. Okay. Mr. Root, would you lead us in our invocation?
Yes, sir. Pray with me if you'd like to. Dear Father, thank you for this opportunity to meet, for our very lives, for the air that we breathe, for all your many good gifts. As we're dealing with law enforcement, public safety matters, we know that love and justice and security are important to you, important to the community. Obviously, you created and hold together this universe, and we do not have that kind of capacity, so we need your wisdom. Pray that you give the committee your understanding, your guidance, your foresight, and you lead this meeting. In your name I pray. Amen.
Amen. Mr. Gary Gollin, would you give us our Pledge of Allegiance, please?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay. Next item on the agenda is approval of the previous minutes, which was September the 17th, 2024 regular minutes. Do I hear a motion?
Make a motion. Second.
All in favor?
Mr. Mize,
Yes, sir.
before we continue, I'd like to make a motion to postpone the last three bullet items due to timing of the time we got started on this meeting to be on a special meeting time, and we'll set that date later in accordance with the open meeting laws. And that's the discussion modification ordinance governing rescue squad and fire service advisory commission, and the solid waste update and the emergency services update.
We've got a motion to.
Make a second.
Got a second? All in favor?
Aye.
All right. Next on the agenda is the discussion items. And first up is for the law enforcement update, Sheriff Mike Crenshaw.
Good afternoon, Mr. Chairman, council members. Appreciate this opportunity to look forward to working through some agenda items here with you. As far as an update, I know y'all recently discussed the 287G immigration program. I'll give you an update on that. Next week, really all sheriffs in South Carolina that have a jail, or the county administrator that might be over the jail, will be on a conference call with immigration to get further guidance on the 287G. Would like to reiterate that this is an incarceration program only. That someone stopped on a traffic stop, deputies are not going to be checking their status. Deputies are not going to be going door to door. Deputies are not going to be going into schools, into churches. It's an incarceration program only. The same as we do now for citizens of the United States that are arrested. We check them to see if they're wanted when they come into our jail in other states and our countries. But we'll get more guidance next week from immigration, and I'll have more information at that time.
Okay, thank you.
The ordinances tonight, several. Mr. Root, I'll defer to you. I know we've met with you and talked with you, trying to increase our effectiveness and efficiency in some areas. And we talked with Mr. Root, wanted to make sure that we don't infringe on anyone's constitutional rights. But, you want to take the lead and kind of go into these ordinances?
Yes, sir, we're glad to. So the first one is not in the form of an ordinance. This is a trespass enforcement authorization program. It is not dissimilar to say what Seneca has. A lot of municipalities have these. They have them in the form of an ordinance. As you know, city, police departments are part of city government. The sheriff is the constitutional elected, essentially deemed a state officer. So the county doesn't have the authority over the sheriff's office as a city council would have over a city police department. So this is put forward as a program, has the same effect if the sheriff wants to implement it. He's indicated a willingness, obviously, to talk about it, and the essence of it is the trespass statutes around, that apply throughout the state require notice. That's where you see the posting, or require warning that someone is on your property, you don't want them there any longer, so you give them a no trespass notice. They know they're on notice at that point in time not to come back on, so if they do, they're trespassing. So it's two ways essentially to give actual or constructive, meaning they should know, not to trespass. This program it really is just a cooperative program with the sheriff's office and business owners or homeowners, whomever, to get the signs in place to note that, hey, you're not welcome here during these particular hours. It could be 24/7 or particular times of the day or evening. So it puts the people who might, be considered trespassers on notice in advance. So if they cross that line, violate the terms of the sign that's gonna be posted here, then they could get cited for trespass. So it's a way for the sheriff's office to work in cooperation with the business, and so an event does not happen without somebody trespasses, but it's not unlawful to the sense it's not been posted or they haven't been, given a notice of no trespass, but they're on the property and the property owner didn't want them there and something happens bad. This gives that property owner an opportunity to work with the sheriff's office in advance to keep those folks on notice of, hey, we're closed now, not welcome on the property at this point in time, what have you. So it's really just kind of an administrative program, is the best way to capture it, I'd say.
Benefit for us, 2:00 in the morning, this is mainly for business owners. So 2:00 in the morning, the deputy catches someone on a business owner's property. And, we don't have authorization to put them on trespass notice. So the next day, that business owner has to come to the office, take out a trespass notice, and then that deputy or another deputy has to go try and find that person to serve them, to place them on trespass. Whereas this was basically a business owner is giving us permission. We'll sign documented permission, and then at 2:00 in the morning, that deputy can place that individual on trespass notice at 2:00 in the morning. And it just, will help us going forward, and it helps that business owner going forward as well.
Is there any questions or points of clarification on that one? That one's relatively straightforward. I think the other two are straightforward as well, but they encompass bigger issues, so that perhaps would garner more attention and should. The first one being, it's called prohibited or restricted conduct. It really goes to solicitations, and this is when we met, issues about, a primary issue would be about folks soliciting for donations in thoroughfares, roadways, and causing public safety issues. This could be folks who are panhandling, this could be folks who are looking for donations. This ordinance is drafted very broadly. It covers all solicitation in all thoroughfares, roadways. So if somebody is in a roadway or adjacent to a roadway, and they're causing a safety concern, being, they're stepping into the roadway, they're distracting drivers, they're approaching vehicles, and you'll see in there, there's also the aggressive solicitation, following somebody, harassing somebody, that's covered. And then particular areas where you can't solicit are covered. The only solicitation that's allowed under this draft ordinance would be special events that are permitted. We haven't gotten into a permit process, but that would be something that would develop from this. This ordinance came from York County. To be very candid, I didn't want to reinvent the wheel on something of this nature. Certainly, most folks know, panhandling is a protected speech. It falls within the First Amendment. If you're going to curtail it in any matter, you have to ensure that you follow some paradigm of public safety, meaning is this gonna cause an accident? Does this distract a driver? Something of that nature. Does it cause, a fear of harm or potential harm to a person who's on foot? So this ordinance, I understand to be tested in York County. I took away some of the parts of the York County ordinance. It doesn't mirror up with exactly. I had some concerns, not to say they've had problems with it, but you need to ensure with these that you don't just hit people who are panhandling, who are trying to get donations of that manner, that it will also cover any other kind of speech too. You can't have content-specific speech. It would just be similar to someone here coming up during public comment and saying, I'm in favor of X, you allow them to speak, and then someone coming up and saying, I'm against X. Well, no, we can't hear you speak. So you can't discriminate on the basis of the content of the speech. However, if there's a speech, regardless, and this panhandling is an example, or even the firemen out there with the boots collecting donations, that's a solicitation, it's the nature of a speech. Either one of those, under this ordinance, would have to be permitted as a special event, so they'd have to go through a process. That hasn't been dialed in yet. This is really the way it's put forward as a springboard for discussion. So that's the first part of the ordinance. The second part really goes to camping, unauthorized camping on private lands and public lands. And, I'm glad to take questions. We can march through it point by point, but that covers the general essence of the first ordinance.
I got one on the, fire departments taking up funds. That's against the law here in Oconee County now, is that right?
Technically, yes. Yes, sir. Under South Carolina law, there's actually a state statute, Mr. Root, correct me if I'm wrong, there's a state statute that prohibits solicitation within a highway right-of-way.
Right, yes, that's my understanding too. And that's the essence of, how you tackle this issue. It's not to take away someone's right to hold up a sign of whatever nature, but to ensure that someone holding up that sign is not into the roadway, is not causing traffic issue, not getting hurt themselves, or is not doing it in such a way as to cause fear or intimidation to somebody else, or is in a particular area that could strike a concern. So that's the way it's drafted. Throughout the country, this issue has been tackled in a number of different ways. Some jurisdictions will say, all right, we're gonna do this. We're gonna make it broader than just the roadway itself and perhaps just 2 or 3 feet that are next to the roadway. The way we've drafted it here, if it causes a problem or could cause a problem, they'll narrow in on particular intersections. We know this to be a high volume intersection. We've had a problem here. That's one way to do it. There are number of different ways to do it, and there's really the best way to navigate a good ordinance is to have a discussion on it, a robust discussion, and ensure, that it falls within constitutional parameters, primarily that you're not restricting one type of speech and allowing the other that would otherwise be the same.
One question I'd have, Sheriff, I know I've seen on social media here lately, correct me if I'm wrong, this should help you a lot. There's been folks, apparently, and you can't believe everything you see on social media, but people have been complaining of being approached in the parking lots.
Yes, sir. We've had calls to that effect.
Okay, so this should really help you out with
Allow us
that.
to address that, yes, sir.
Okay. Are there any other questions?
I mean, it looks like it lays out the public safety concerns, right? So you have that wedge angle, and it's broad enough to where you're not singling out anything specific.
Yes, sir.
I think the only thing that would be definitely missing, subject to any other questions, comments, or ideas on tweaking it, would be to work with the sheriff's office and the county administrator to figure out an appropriate permitting procedure. What kind of organizations can get permitted or individuals can get permitted and how. That can be something that we bring back, assuming y'all want to go forward with this, that we bring back to committee. It could be on the special meeting that's gonna be scheduled, or it could be something that just goes straight to council with this ordinance, and we could work it up at that point in time. Sort of subject to the commission's, or committee's pleasure.
Yeah, I think we need the whole picture, right, to, I'm gonna put half of it out, then have to come back and finish it up. I think the whole process needs to be put together. Kind of to backtrack a little bit, we talked about the no trespassing. I like to change just a little bit of the wording in there to include where the signs are purchased. Include that the purchase at cost, whatever that cost is to the county. I don't want the businesses getting the signs to cost the taxpayers, but I don't want there to be extra built in on that. And then some kind of language to indicate that the property owners or the management, all that property is responsible for the installation of the signs. That way they don't expect the sheriff's department, the sheriff's office to be out there installing the signs.
That's, the one issue is just to ensure that they're placed properly would be.
And it's written in there that the sheriff's office can advise on how to replace them. Say, sheriff's office advise where the placement, but
I
to climb up
foresee
on a ladder and hang them.
Giving them a guideline, you know, it has to be this height, this parameter. You know, we would give them very specific instructions. Would we purchase those signs, or would the county make those signs?
We would probably end up purchasing those signs, Sheriff.
Okay.
County Road Department, we do have a sign shop. We are capable of making signs, but we typically don't make building style signs. Every sign that we make has to be up to NTSB standard, which means it has the micro-reflective materials, the border of reflective material. It has to be posted a certain size and a certain height because it is a roadway sign. I think it would be better for the county to order a custom sign of such. And then for Mr. Durham to address the responsible for placement. Currently, the no concealable weapon signage has criteria for how high it must be up from the base of the building and how far it must be from the entrance of the building. We could do something similar to that.
Okay.
So what I'm getting from that, are we gonna put the specifics in this ordinance that specifies the exact size so that everything will be uniform?
Yes, sir.
Okay.
And then from Mr. Durham, I think you'd like for us to go ahead and put the permitting process in there and come back to committee meeting?
Yeah, for the,
Okay. Or future committee
yeah,
meeting?
that's right. We can put it in, you know, if we get enough time on the next one, we can schedule it for that.
So for those two, I'll just work with, since it's a program, the sheriff's office is gonna run with it. We'll finalize out the trespass enforcement program, and he can take that, addressing the cost of the sign and nature of the signage and who does the installation at the sheriff's office direction. And then we'll bring back the, restricted conduct, the solicitation and camping to address, the permitting process for solicitation. We'll have a permit form.
Okay.
The other ordinance, if the committee's ready to move forward with really the final one that we have on here, is the public nuisance. That's the caption of it. There's no real good page break, but it's the public nuisance ordinance. And I apologize, in some way how in translation, the ordering of it got off. This, again, is an ordinance that was borrowed in large part, I'd say, from Richland County. I know one of the former deputy county attorneys over there who is a very good attorney and did a lot of their code enforcement work. And so I talked to him about the nature of this ordinance, how effective it was there. It was relatively effective. It does come down to, of course, again, how much personnel, how many personnel you have available to work on these with the sheriff's office or with code enforcement folks, and then that nature of that cooperation with county government. What this does, and I think the issue we were talking about when it first came up, were places of business and some residential, and I'll talk to that later, but primarily places of business that have repeated breaches of the peace, repeated infractions, in some way to cite the owners who can be responsible. They might not be the folks who are, carrying out these, have, controlled substance issues or prostitution or anything of that nature, but they still are the ones who are essentially making the operation run, allowing it to run, not doing what's necessary to keep it from happening. So this provides an opportunity, it defines the nature of these public nuisances. In large part, it tracks with the state statute that I'll talk about in a moment. But this gives, if these events occur on a repeated basis, and they're breaches of the peace, and these can be gambling, and I should have looked it up, a bawdy house, I don't know if that's a house of prostitution, or I meant to look up the definition of bawdy house. But, you know, where you have assignment, prostitution, unlawful manufacture, sale of liquor, controlled substance issues. So you can do something aside from, you know, hitting this particular person who's there who violated the law. You're actually hitting the owner also. So this gives that opportunity. I think we were talking about it before, is there a means to really just shut down the operation? And that's where we get into the state law issue. And as we've talked about, I guess a number of times, there are certain areas in the law that when you have a state statute that's on point, it's called preemption. Sometimes the state just very clearly says, hey, county, thou shalt not make any law that infringes into what we're doing here. Usually, it is a matter of state law has to be uniform in its application. And sometimes they will specifically say, all right, local government, y'all can do what you would like in this particular area. This area, when it talks about forfeiture of property, taking property, shuttering businesses, really appears that, and this is the section that's included in the backup, it's SC Code 154310 and following. This is an abatement of nuisances, similar language, similar types of continuous breaches of the peace, but it's an injunction program. It's generally, and I think in this case, most likely to be prosecuted, although it's a civil matter, prosecuted by the solicitor's office. Attorney General has, you know, kind of plenary authority over this, but it's usually delegated down to the solicitor's office. And in that case, when you have similar events, which you talked about, which I talked about, that could cause a misdemeanor violation under the ordinance that we're talking about now, here you could get the Attorney General or solicitor to bring an injunction action that could shut down the business or shutter the house, what have you. So that's why it doesn't, we talked about this when we met, that's why it doesn't cover, the local ordinance doesn't cover that broadly. I think that's, if we get into, you know, forfeiture issues, shutting down houses, businesses, that is where the state law has to take place. And that's something that the solicitor's office would be the enforcement of. Not dissimilar to, again, to a forfeiture action in a drug case, I guess.
Benefit, just in summary for us, you know, sometimes we get reports in a community or a neighborhood, there's a lot of traffic going in and out at a certain house, disturbing neighbors, keeping neighbors up, small children living in the area, and sometimes it can take months, even year or more, to build a criminal case. This gives us an opportunity, you know, my focus with this would be for drug houses. You know, if you're operating a drug business in Oconee County out of a home, and it's causing a disturbance and disrupting your neighbors, then we need this would give us the benefit of hopefully being able to address this at the county level through the ordinance. And then hopefully we could take that further with criminal charges and the solicitor addressing it with the state statute that he's talking about. Yes, sir.
We still have any reports on poker machines in different vicinities that are doing it when they shouldn't be?
We currently have 2 in evidence, I think a couple, that we're waiting on, get word back now from SLED, whether or not, they're gonna go forward with criminal charges. But, we get those reports, from time to time, yes, sir. Not frequently, like years ago, but occasionally we do get a report of gambling machines.
I was just curious, I've heard rumors myself.
Yes, sir. And again, this would be this ordinance would give us an opportunity to address situations like that as well. You know, we would document what we needed to document in the ordinance, whether it's calls for service, whether it's, you know, repeated issues that we've had from coming from that as a result of that, arrests as a result of that. And And then, I guess the process of that would be, we would go through codes to address that.
Yeah, it could be. I think it really could be approached in a multi-pronged way. It could be a code enforcement action. Usually these houses have something that would violate the International Property Maintenance Code, could violate the existing building code. So those elements could come in. And certainly this would allow for the county level misdemeanor. So you have the magistrate's jurisdiction capping out at $500 through 30 days. This would allow that citation for the sheriff's office. And then it also bleeds over into the civil, we'll call it quasi-civil case, but a civil case that the Attorney General's or Solicitor's Office could bring that would essentially shutter that business, shut down the house, what have you, so, because they, same elements of the offenses.
Sheriff, do you support this ordinance as written?
I do. Of course, Mr. Root sent it to me. I've read through it. I think I'm good with it. Obviously, for council, full vote, I'd want another opportunity to review it. Let's really drill down on it and be sure, but I think we are.
Mr. Root, do you see any other concerns?
I don't,
Keep us
the
informed.
numbering concern probably triggered my OCD more than anything, that it was off, but the content of the ordinance is sound. I do agree with the sheriff, I'm not a criminal attorney. The solicitor's office, with the sheriff and myself, I think would be good to take one more look at it, make sure it's pinned down and put it in final ordinance form. And we can bring it back here. I don't see any substantive changes to it that being necessary, but they are the folks who do this on the daily. So we may have some changes that are material.
So we have the sheriff do a final review in the solicitor's office and then bring it back and we'll go from there.
Yeah. I've talked with Solicitor Black about it already, and I said, once we kind of get it drilled down, I'll get it to him, so I'll go ahead and do that.
Okay.
And for review and get back with Mr. Root.
Any other comments? Okay. That was the last item on the agenda that we're gonna discuss today. Do I hear a motion to adjourn?
Make a motion.
Second?
All in favor?
Aye.
Aye.